Our last speaker of the morning is the Honorable Paula J. Brownhill. And she's going to be talking to us about protective orders and firearm surrender. Judge Brownhill is our presiding judge. She's been an attorney since 1981. She was U of O grad, undergrad and law school. And she's been on the bench here since 1994 when she was elected. She was the former family treatment court judge. She's a dependency judge. I think she's the best dependency judge in the state. She was briefly in private practice, I think, before she took the bench, but that's my recollection. Once in Coos Bay and Astoria, right?
I was a public defender in Coos Bay.
Oh, all right. Well, I was just wondering, did you ever practice with Blair? That was my big...
I did.
Did you?
Yeah.
That was something.
Years.
Oh, wow, I didn't know that. Okay. Learn something new every day.
Where do you want me?
Right over here, Judge.
Okay. Okay.
You got your... Okay, good.
Okay. Can I make it stationary?
What's that?
Can I put it down?
Oh, sure.
I want to sit. Okay. Thank you. What? Oh, okay. All right, so I started this a really long time ago, and at my very first judicial conference, it was in 1995, it was a really boring speaker, and I looked around the room and all these judges are just rapt attention, listening, and I realized then that's a learned trait. Judges have to learn how to look interested when it's really boring. And you all did a really good job with Mr. Chamberlain. So I'm going to talk about 6 protective orders. That was just a joke. 6 protective orders in Oregon that people can get on an ex parte basis. They can come in and get it without the other side being present. There are other kinds of protection orders that people can get, but generally they have to pay a lawyer to get those. So we'll start with FAPA. Now see, I said, Crystal, you can do it. Otherwise I have to turn around. Thanks. So we're going to start with FAPA, Family Abuse Prevention Act restraining orders, and emphasize the family. There has to be a relationship between the petitioner and the respondent to qualify. I have this great handout. I have one for each of you. It's right behind Ron there on that table, and it summarizes all 6. So there has to be a relationship. So it has to be either adults related by blood, marriage, or adoption, adults who were in an intimate relationship fairly recently, the unmarried parents of a minor child, or the only child who can obtain a FAPA order is one who is married to or in an intimate relationship with an adult. So those people can get them. We can order all kinds of things in a FAPA. We can order no contact or limited contact or contact just by text message. We can grant custody, parenting time, possession of the dog, emergency financial assistance, although there's no way for a petitioner to collect money that we order in a FAPA, so I don't order it because it gives them some expectation that they're going to get money that they'll never get. We can remove them from a shared home, restrict from going places, and I think Mr. Brown sent out a memo a while back that said if some officers are saying whoever gets to the place first gets to stay if there's a FAPA order. That's not how it works. The respondent is the only one who is restrained in a FAPA, so the petitioner doesn't ever have to leave. They may want to leave, but they don't have to. Only the respondent has to. And we can order no firearms in a FAPA order. Now there's an Oregon law that prohibits firearm possession if you're the respondent in a FAPA, and there's been federal law for years. So back in 2008, we created a firearm surrender program for FAPA orders. Mr. Brown was on the work group There were some chiefs on the work group. Anyway, we developed this. We were probably the second county in Oregon to come up with a firearm surrender program. It's been in effect ever since. We don't always order surrender of firearms in FAPA cases. I always order no firearms. You can't own or possess firearms while the FAPA is in place. But I only order surrender if there was a gun used, a gun threatened to be used, or if the petitioner knows that respondent has a gun or doesn't know for sure. But if the petitioner says he doesn't own a gun, I don't order surrender because it just causes a lot more paperwork and doesn't do much good. And we can order a police standby. I think this might do it. A police standby, and that's just for essential personal property. You don't get a police standby to take your clothes out or your TV set, just for essentials. Okay, so next slide. To qualify, within the last 6 months, respondent injured, tried to injure, threatened to injure, placed petitioner in fear of imminent injury, or forced petitioner to have sexual contact, and petitioner is in imminent danger of further abuse. I'm telling you about these protective orders because we get petitioners all the time who come to court and say, the police officer told me to come and get this order. Many of the people you send to us do not qualify, and one of the reasons is this imminent danger of further abuse. In one case, SMH versus Anderson, petitioner and respondent were in a relationship, and he was abusive. He injured her. She finally broke it off with him, and then several years later, he called petitioner's friend and said, hey, how's she doing? Where's she living? Petitioner came in and got a restraining order, a FAPA order, because she was afraid that he was going to hurt her. The trial judge gave her the order, and the Court of Appeals reversed, saying she is not in imminent danger of further abuse. So that one was thrown out. In a similar case, CMH versus Ackley, petitioner and respondent were dating for 3.5 years, and it was a very volatile relationship, a lot of fighting. And petitioner finally broke up with respondent, got the FAPA order, allowed him to have contact only by email. And he violated the FAPA order a number of times. He came to her office. He told friends he was going to go to a performance that she was attending. She was afraid of him and obtained a FAPA order from the trial court, and again, the Court of Appeals reversed. She's not in imminent danger of further abuse. So not everyone qualifies for these. Although I would say of the 6, this is probably the one that we grant the most often, the FAPAs. The Elderly Persons and Persons with Disabilities Abuse Act is very similar to the FAPA protective order, but petitioner doesn't have to have any relationship with respondent. Petitioner has to be 65 years old or older or have a disability. Almost everybody has a disability. Almost everybody would qualify to apply for a restraining order under this one. I call it FDAPA, but whatever. Next slide. We can order no contact. We can order out of the home. We can restrict from going places. We can order no firearms, and we can order surrender of firearms, and we can order the police standby. But this one is tricky because the law says that a person can obtain one if there's physical injury or neglect that led to physical harm or abandonment, willful infliction of physical pain, use derogatory names, or threatened to hurt someone or emotionally harm them. That's the one that's a problem, because people come in thinking that they're going to get a restraining order because grandpa called them names or vice versa. That's not enough. Calling names is not enough, even though it looks like it when you look at the law. But taking property from the elder or disabled person may qualify. But again, on this one, there has to be immediate danger of further abuse. So, on the derogatory names, the reason that that's not enough is the First Amendment or Article 1, Section 8 of the Oregon Constitution. It has to actually be threats, and they have to be real threats, not just indirect threats. Stalking orders. This is the second most popular protective order in Clatsop County, and this is where we see so many of them where they say the police sent them. They could be fibbing, but it might be that you send a lot of people into the court to get stalking protective orders. Adults and minors can file. Respondent has to know that the petitioner doesn't want contact. So if respondent's been calling, emailing, that's not enough. The petitioner or a police officer has to tell respondent, she doesn't want contact with you. Stop contacting her. Then 2 unwanted contacts after that notification to respondent, and it may qualify. But the contacts have to put the petitioner in fear of physical safety, either the petitioner's or some member of the family. So the contacts could include physical violence, following petitioner, spying on petitioner, but if anything verbal has to instill a fear of imminent, serious physical, personal violence, and likely to be followed up by illegal acts. So it's not just a threat, it has to be likely to be carried out. So the petitioner has to feel personal apprehension. He has to feel afraid or be worried that he's really going to get hurt, and that has to be objectively reasonable. So a reasonable person in that person's position would be afraid. The threat, if it's a threat, has to be direct. You can't just say, I wish you were dead, and that qualifies for a stalking order. It has to be a real threat. So, my plea to you, please don't use these for neighbor disputes. Neighbor disputes are not stalking situations unless there's actually violence or likely to be violence. So the neighbor who sits in his driveway and watches everything the next door neighbor does, that's not stalking. It seems like it might be, but it's not. Calling names? Nope. Yelling at the kids? No, probably not. I don't know how to pronounce his name, but Kirk Kazee, is that it? Kazee? He was peeking in people's windows. That qualified. But that was criminal behavior, and it was a lot more than just calling names or watching what the neighbor did. We can restrict access to places with stalking orders. We can restrict all contact. One reason it doesn't work for neighbors is because part of the order is that you can't come into the visual presence of the other person. And when you live next door to somebody, it's really hard to avoid that. So if you find someone has violated a stalking protective order, it's a mandatory arrest. It's a crime. The orders last forever, so it could be 10 years later, you can arrest somebody for violating a stalking protective order. And so I'm going to tell you about some stalking cases that seem like they really would be stalking, but the Court of Appeals doesn't think so. So the first one's Dmg Versus Tepper, and in this one, the respondent smeared sardines all over the petitioner's car. He was with some friends at a sporting event, and standing right behind the petitioner said, "Wouldn't it be funny if I maced her?" That wasn't enough for a stalking protective order. It has to be an unambiguous, direct, unequivocal threat that expresses to the petitioner that the threat's going to be carried out. In King versus WTF, petitioner and respondent were having an affair while they were both married to other people. And finally, petitioner said, "No, I'm calling it off, we're done." So respondent emailed her, texted her, posted on social media about her, sent her letters, sent her flowers, begged her to come back. On her birthday, he went to the Starbucks where she was working and left her a birthday gift and a card on one of the tables. She was afraid of him and obtained a stalking protective order, and Court of Appeals said, no, that's not stalking. In AMM versus Hofer, petitioner and respondent were dating. She broke up with him. Respondent set up a fake Facebook account and called himself Shauna Blaze. And Shauna Blaze communicated with petitioner's friends on social media, got familiar with one of petitioner's male friends, and who thinks he's communicating with Shauna, and it's really this guy. And so the man invites Shauna to the nightclub with petitioner. And they all show up there, and Shauna called petitioner some names, said she was a whore. He left personal property in her driveway. She was afraid of him. Court of Appeals said, that's not stalking. And my favorite one is RMC versus Deacon. In that one, respondent dressed in a rat costume and walked back and forth in front of petitioner's restaurant. Now, petitioner thought he was trying to get her restaurant shut down. It certainly did affect her business. He did it for several days, for hours at a time. This guy must have had nothing else to do. Court of Appeals said, no, dressing like a rat and walking back and forth in front of the restaurant is not stalking. So.
Is it lack of proving an unwanted contact, or what do you think?
It's the danger to your physical being. Yeah. So, yeah, you can't say, you're going to be sorry you did that, or I'm going to destroy you. Those things don't qualify. It has to be, I'm going to kill you, and really, you think they really might mean it. So. There's the sexual assault protection order. On this one, adults and children can file. They can't be family or household members, so a child can't get one against grandpa or stepdad. They can't have any other protection orders in place, and the respondent has to be an adult. These have been around for a long time, but I have never done one. I think Judge Matthias has done one, but they don't come around very often because they're hard to qualify. Plus, if criminal charges are filed, they can get no contact orders, which probably are as effective. Okay. I don't know what I do with the rest of my notes. So the next one is the extreme risk protection order. And that one's fairly new. Here it is. That one, adult, family, or household member can file, or a police officer can file. And I don't know if any of you have ever filed for one, but they were put in place, I think, to take guns away from people who are unstable, maybe have made threats of suicide or acts of violence against other people, somebody who's using or displaying a gun, using drugs, recently acquired a gun, or has certain criminal convictions. So you can apply directly to the court, and the judge can prohibit the respondent from owning, possessing, or acquiring deadly weapons, and require a respondent to surrender the deadly weapons. So like I said, they're pretty new. I don't think we've ever had one. But it's available to you if you have concerns about somebody out there who shouldn't have weapons. And then the emergency protection orders, and we've had these for several years. Our court has never issued one and probably never will. Only a law enforcement officer can apply for the emergency protection order. I was at a judicial conference a few years ago when this first took effect, and one of the judges from Deschutes County was walking next to me, and he said, you know, everyone in Deschutes County hates you. And I said, really? They do in Clatsop County too. Why in Deschutes? And he said, because you got that emergency protection order law passed, and now we have to get up in the middle of the night and issue orders. And I said, I didn't have anything to do with that. I don't even think it's a good process. Because what happens is you're in the middle of the night, you're at the scene of a domestic assault. Why would you call me to get a restraining order? You're going to arrest the perpetrator if he's there, because it's a mandatory arrest. If he's gone, you're not going to be able to serve him with this order that you get on the phone in the middle of the night. So it just makes no sense. So I didn't have anything to do with passing this law. But anyway, the person has to be in immediate danger of abuse, and an emergency order is necessary to prevent a reoccurrence of that abuse. They only last for 7 days. So it's really just to protect the victim in the middle of the night, but you can do that in other ways. Although if you do, just an interesting little quirk, if you do pick up somebody and lodge them and the jail lets them out, and they have a no contact order on their release agreement, and they violate that by going back to the victim, often the officers will arrest and take them back to jail for violation of the release agreement, which is not a crime. So when we get those PC affidavits for violation of release agreement, we can't sign them. It's not a crime. It could be contempt of court, but it's not even contempt of court, because it's a release agreement issued by the jail. So there's-
What if a release agreement? What if they're arraigned prior to?
And we can file.
huge arrest?
Then it's contempt of court.
Okay.
Yeah. Yeah, but if it's just one from the jail, you can still do it. I mean, it'll interrupt their pattern. It'll get them off the street for a while.
So my recommendation to you, officers who have issues with that, and you take someone to jail for that, and really feel like they're gonna be a problem, and the jail's getting ready to kick them, try to find a supervisor from the sheriff's office, because we can try to maybe get them arraigned the next day and not get kicked out so fast. If that's the case, maybe see a judge, and the judge can decide. Case by case, only, please.
So that's all I have.
Any other questions?
Oh, yeah.
You answered the no contact one, but civil standbys. As a sheriff's office, we serve the majority of restraining orders, stalking orders, and we take care of that. And we try to, no matter where it's at, we try to get the civil standby done if there is one right then and there. And most of the time we get that so the emergencies don't happen. However, we have seen them sometimes where it just says, for instance, I had one where the guy had a landscaping business and it said on there, he can get whatever is pertinent to his business. And then
Tools of the trade.
Then the other party goes, I bought all that stuff. And we get into kind of a hissing match, for lack of a better term. Or it's really vague on what they can get. Personal items, and he goes, well, the vehicle is my personal item, I want to take it. And so I don't know how we can, I don't know what we're supposed to do as the person on the scene where we're not going to get ourselves jammed up giving somebody something that doesn't belong to them. How do we mediate that? What is their requirement when they come in to tell you what exactly they need? How do we get specific with that?
Okay, let me tell you what we can order you to help them with. It's like social security card and driver's license, and it's just the essentials, yes. So tools of the trade may be, but if there's any argument, I would say you walk away and tell them, see a judge.
Okay, that's what I did in that particular
Yeah.
circumstance.
That's the best advice. Yeah. Any other questions? Yes?
Clarification on imminent. What does your court consider imminent now with the appeals court or the Supreme Court? They come in my office and I try to explain to them what imminent is, and of course they're all in denial of what I think imminent is. But what does your court going to accept your own?
Well, let me preface that with there are 3 of us, and the 3 judges don't always see things the same. So I think imminent means it's going to happen very soon. You know, like if he's in Wisconsin, that's not imminent. But it's going to happen within the next maybe week, 2 weeks, that's imminent.
Okay, so if they're in Portland, then it would be imminent because they could make it down here.
They could make, yeah, yeah.
All right, thank you, Your Honor.
Yeah.
You gotta go slow on recommending stalking orders to victims, it isn't Z case that the judge mentioned, because he wasn't arrested right away because he had to process his phone and find all these videos that he'd been taking of all these girls in their bedrooms. And so he was out on the street. All he had for was trespass too, I think, originally arrested for. He came waltzing in trying to get his phone the very next day. Luckily, he wasn't given that. And then we processed his phone. But various of the people that were the victims down there in Sir Pines went in and tried to get stalking orders. Well, Mr. Kazee, he was pretty resourceful, and he had this kind of thing happen before. So he hired his own lawyer. And his own lawyer, if you go in and are unsuccessful in a stalking order, then you can have to pay the guy's attorney's fees. So basically, we had to jump in, file criminal charges, and we headed off all those stalking order problems the victims' families were going to end up having because he was already out of circulation. But that can be a problem. They can end up getting tagged for the bad guy's attorney's fees, particularly if they just wander in there without their own lawyer.
There is a way around that. There are two different ways to get a stalking protective order. There's the one that has attorney fees connected with it, and then there's the police officer's citation. So if you do a citation for stalking protective order, the victim won't ever have to pay attorney fees. Yeah. Hey, lunchtime.
Appreciate it.
Thanks, Ed.